I can tell you in 1 minute that the Arena referendum petition case is still pending, and shut up and sit down. But there's more to it than that that's going on. Always keep in the back of your mind that this starts with the greatest innovation to our old 18th century Constitution and Bill of Rights, with Oklahoma's Bill of Rights at the beginning of the 20th century, which Oklahoma's Bill of Rights begins with this statement. It kind of is in the preamble to the United States Constitution, but our Constitution's Bill of Rights starts with this: all political power is inherent in the people. And our Article 1, which is our Article 5, which is legislative authority, says the legislature is vested with the right to legislative authority in Oklahoma, but really the people reserve the right of all legislation themselves through either the initiative or referendum. Our legislative representatives, our elected representatives, our governors, are trustees for us. They are not to rule top down. We have given them the day-to-day authority to legislate for us until we determine that they have abused the privilege. And then we are to take it back. And that is what we did here. The people are sovereign. That comes, and Neil knows all about this because he would work with him when he was on the court. There was a justice on the Oklahoma Supreme Court in the 2010s and early 2020s who since left for the federal bench, who started emphasizing these things in the dissent on initiative petitions and referendum petition cases. And his thinking, which was the right thinking, eventually found its way over to the majority, and he started finding himself making these points of emphasis in concurring opinions. And that is kind of where hope comes here. All right. Uh-oh.
I don't know what happened. No, you just hit that button.
I hit the wrong button because it ain't my computer. There we go. I got to hit that button. Got it. Got it. So here, now we get into the Arena referendum petition update. And there's more story. We have our case, the Rock Creek Entertainment District referendum petition. Mechanically, that appeal was filed in March. We are now in October. It is still pending. We have a motion for oral argument, still pending. Don't get too worried and stressed out about that. Cynthia actually likes some of the passage of time for her reasons. I like some of the passage of time for my reasons, one of which is the opponents of the referendum petition were dead hell-bent on getting a lickety-split fast-track decision from the Oklahoma Supreme Court where they weren't paying attention to the case, and before the new city council got seated, they would decide it in June. They tried to double-dog fast-track it. We were okay with the first fast-track. We were not okay with double-dog fast-tracking it. And I think technically what has happened is the Supreme Court has agreed with us that we don't need to double-dog fast-track it. The petition opponents complained in one of their filings that we want it to go fast but not too fast, as if that was a bad thing. I was like, well, yeah. We want to get this over with and get this to a vote of the people too, but we want you guys to actually pay attention to this case. I think they have. And the other cool thing that happened, a funny little thing happened on the way to our case being filed and going through the process. Two other big boys came up and are all with us at the same time. Our supermajority in the legislature decided in their wisdom that they would pass a law virtually annihilating the initiative and referendum petition process, making it almost impossible to do, and I would say almost impossible to do in rural areas, which is what they said they were doing, is making sure people got out to rural areas. But some of our researchers with ORED and Pykoff figured out real quick that it was doing exactly the opposite. That what it was doing was it was taking away the right of referendum petition not only for urban folks, but also for rural folks. This started to resonate. Here we got Russell Rice, Pam Post went up to the legislature, Tanner Nair went up to the legislature, I went up to the legislature. There was a one-page flyer that started meaning something to the rural Republicans, and this was starting to go down in flames, and then the leadership started twisting arms. And brought everyone back in line, and it passed. But of course, as we knew, it was going to be challenged right away. So that got linked up with our case. Then we knew this was coming along, but the legal challenge came in at about the same time. State Question 836. We're still pending. Senate Bill 1027 legal challenge is still pending. Oral argument is set for November 18th, 2025. So they will decide it sometime after then. So that's what we know about that case right now. I feel real good about most of this bill being stricken down, but I don't decide, like I've said before. It's in the hands are in the fate of judges. State Question 836, open primaries. I kind of call them city council primaries, because that's what our elections would look like in the way, if this passes, our elections would look more like a city council election, like what you see in Norman and Oklahoma City and Tulsa, where everyone just goes on a primary ballot. And the top 2 vote getters in the primary proceed on to the general election. It's not everyone gets to vote in each other's partisan primary. It's everyone just gets thrown into the same primary pool, like a city council election.
If somebody gets 50%, do they win outright?
I've got to still figure that out. I've been busy with this and this,
Okay,
more so than this. But yes, that's a good question. Now this is, we'll keep this up and you can get, this is, they're going to be out getting signatures here starting later this month, and they're going to have 90 days. This is a link to their site, and I am trying to emphasize to them in no uncertain terms that they will rock their signature gathering efforts in Norman. And the new rules wouldn't apply to them. They're going under the old rules anyway, but their goal is to get 173,000 signatures. So it's a tall order, and they have 90 days to do it. We had 27 days to get ours. And the cool thing about the way they did it, at the statewide level, if you do an initiative petition at the statewide level, you get all your legal issues sorted out first before you go out and get signatures. So if you're just as bad, and guess what? When you work it out beforehand, maybe the Supreme Court says we shouldn't be so tough on the gist, because they're just going to go back and file a new case and fix their paperwork anyway. So you get to fix your paperwork before you go out and get your signatures if you're doing a statewide initiative petition. With us, it's completely flipped and it's completely opposite. We were having to work under the hardest rules that had ever been established for getting signatures. And we did fantastic. Training, our signature gatherers were really persnickety and made sure they got good signatures. We had like a 91% rate of retained signatures as opposed to thrown out signatures. And we might, if we thought it was a problem, we might could have gone back and saved some of the ones that Brenda Hall said were not valid. But we had a 91% rate, which is about as high as it's ever been, I think. But we had to do that in effectively 27 days. And then we go, and of course, with a referendum petition, what do? They attack the gist. So if you're just as bad in a municipal referendum petition, you're done, you're gone, it's over. You don't get to go back and try again like they would have. Now the cool thing is they had a gist challenge and they passed it under kind of a standard and an opinion we like and arguments we like. That's the link. We've got it up. It's on our things. You can come up and take a picture afterwards, so you can go right to the link and get on the list for volunteering to circulate signatures and gather signatures. So here we go. What's at stake here? The Rock Creek Entertainment District must go to a vote of the people. Even the county commissioner's attorney has said so recently. The official position of the county commissioner seems to be that it needs to go to a vote of the people. Now, of course, those three commissioners And I would say there need to be candidates up for their offices. Those three commissioners are bound and determined to make this project happen. But their official position, knowing what maybe they saw in the last set of city council elections, is, okay, we agree it needs to go to a vote of the people.
Yeah, they said that 3 months after they approved the economic development agreement.
Yes. Now, and to give you an idea, I'll tell you what the base legal argument is in our arena referendum petition challenge. We are saying that a gist has to be measured against a fraud, deceit, and corruption standard. And we're on solid grounds with the law there. And we are saying that a gist cannot be stricken down unless it shows, indicates clearly fraud, deceit, and corruption. What the other side, and that's kind of the tack they took in State Question 836, what the other side says is that a gist has to contain every material detail of the measure. Now, how in the world can you put in every material detail of the Rock Creek Entertainment District project plan? You can't. The thing is this thick if you print it out. You can't possibly do that. So I believe we're confident we're on the better side of the law, but it's ultimately up to the Supreme Court. Here, a win on the SB 1027 legal challenge clears the path for an initiative petition to rein in the Oklahoma Turnpike Authority for all time. Another thing you may not be aware of, you can see it in the public record if you look through the SB 1027 challenge, is that Pikeoff is and was well on its way toward formulating and getting out an initiative petition to stop the OTA, to rein them in for all time. And unfortunately, SB 1027 would annihilate that effort. That's another reason why Pikeoff had standing and Pikeoff was wanted. Is it was already known in some circles that Pikeoff was well on its way to an initiative petition, and therefore they were an appropriate petitioner in that case. Now, what we're talking about here today, Cynthia's given nuts and bolts. She's going to come in with some more practical stuff here in a minute. It's not just about a bill. It's not just about a measure. It's not just about a political issue. It really comes down to, this is part of who we're going to be as a community, as a state, as a nation. Are we going to retain the rights of self-determination at the ballot